the very idea of administrative law was traced to France, and in France its origin and development was in the form of droit administrative, which was a body of rules determining the organization, power and duties of public administration, and which regulate the relation of the administration with the citizen. It was not represent the rules and principles enacted by Parliament. It contains the rules developed by the administrative courts. So this was the origin and development of administrative law in France in the form of droit administrative. It includes these three senses of rules, and those are the rules dealing with administrative authorities and officials, and the second one, rules dealing with the operation of public service to meet the needs of the citizens, and the number 3, rules dealing with administrative adjudication. And as this droit administrative, as it was developed in France, and when it came into practice, it was put into regular practice by the then French Emperor Napoleon Bonaparte by establishing Counseil d'Etat in 1799 to give relief to citizens against the excesses of administration and to resolve the difficulties in administration. But later it started exercising judicial powers. In 1873, it was settled that in all matters involving administration, the jurisdiction of the Counseil d'Etat would be final. So, in France, there were 2 types of courts. At that time, one was the regular courts, and the second one was administrative courts. So, in regular courts, it was the subjects versus subjects. And in regards to administrative courts, it was subjects versus state and administration. So, in France, administrative courts were the foundation of administrative law as it was developed from droit administrative, and in the time of Napoleon Bonaparte, by establishing Counseil d'Etat in 1709. So how the development of administrative law and its growth spread to other parts of Europe, that we'll discuss, and regarding that we'll go to England. It was first explained and defined by Professor A.V. Dicey, and after that, Professor Maitland in his Constitutional History of England described about administrative law, Queen's Bench division, etc. And this development made by Professor A.V. Dicey and Maitland led to the establishment of a new committee by Lord Hewart for the establishment of Donoghmore Committee to control delegated legislation, subordinate legislation, and quasi-judicial decisions. And according to the Donoghmore Committee and its suggestions, the English Parliament enacted the Crown Proceedings Act 1947, which substantially changed the very principle that the king can do no wrong. So Crown became liable for the torts of its servants. And after this development, a committee was established which was known as Frank's Committee. And the Frank's Committee recommended for the establishment of certain tribunals and inquiries, and according to the recommendation of Frank's Committee, the Tribunals and Inquiries Act 1958 was established and enacted, and it was amendment in 1971. Then the Justice Committee of International Jurists recommended appointment of ombudsman in England, and it was adopted in 1967. After the development of administrative law in England, now we'll discuss about its development in United States of America. In United States of America, administrative law and administrative agencies are considered as old as American government, as because the first Congress enacted the statutes conferring important administrative powers to administrative authorities and agencies. And consequently, the Congress enacted Interstate Commerce Act 1887, Special Committee in 1933 of Congress, and the Attorney General Committee in 1939, which submitted its reports in 1941, and accordingly the Congress of United States of America enacted the Federal Administrative Procedural Act, and that was enacted in the year 1946. And before that, another major development was made in the American Constitution, and that was regarding the enactment of Social Security Act of 1935. And that was regarding social welfare, environmental issues, automobile accident compensation tribunals, and administrative tribunals exclusively for environmental offences. So, by this way, most of the tort cases gradually transferred to administrative tribunals. So, this is the development of administrative law and its growth, its origin from France and in the form of droit administrative, and how it was put into a practical and important emphasis by the then chairman and emperor of France, Napoleon Bonaparte, by establishing Counseil d'Etat, and how it came into influence the English jurist and how it became part of English judicial system in the form of Crown's Proceedings Act in 1947. So also how it spread to United States of America by the Tribunal Administrative Procedure Act of 1946, Social Securities Act of 1935. So this is how administrative law originated from France and how it spreaded to England, United States of America, even to India. And in context to India, in our upcoming video, we'll discuss about its origin and development and its impact on Indian judicial system.